The EEOC was established on July 2nd of 1965, and this happened by way of Title VII of the Civil Rights Act of 1964, which prohibits discrimination in employment on the basis of religion, sex, color, national origin, age, and discrimination. In this episode, we're not just talking about the EEOC, but we're going to dive into the EEOC charge process so that you understand once a charge has been filed, what happens next, when is the beginning, and when is the end, all about the EEOC charge process. I will say that there's nothing quite like the panic you feel when you receive your first EEOC compliance charge letter. It is so aggravating, it's so confusing, it's so anxiety filled that it's hard for you to not get freaked out. Now, if you've been through a process like this a couple different times, you know what to expect as an HR leader, but it's entirely new, likely, with your leadership and executive team. So not only do you have to understand the process, but then you have to explain the process to your leadership. I have a handy dandy graphic that I'll show here in just a minute that's going to walk you through the steps. Now, we use this particular graphic in reviewing our HR certification prep class. We go through this graphic and we talk through the process, so I figured I would show it here. Now, I mentioned the letter. That's really step one of the EEOC compliance process. But first, your employee will get in contact and visit the EEOC website to file a charge. Basically, they feel like they've been discriminated against one of the protected classes as listed and outlined in Title VII. Once they have received the charge, and sometimes they have an initial conversation, and by they I mean the EEOC, with the particular employee or candidate in question, and then at that point they'll notify you via letter. When you receive the letter, normally you have to provide a response. So it's helpful if you've already conducted an investigation so you have copies of notes and information. Oftentimes, this is the moment when you need to talk to your counsel or your employment law attorney to walk through exactly what needs to be done. However, in my experience, when we've had our EEOC charges and my HR experience, I luckily had documentation, so I had record of what was said and how it was said in the investigation that was done. You'll send that information directly to the EEOC. Well, they'll review that information. Sometimes they might call you back for a little bit more information, but they often then conduct an interview with the person who has filed the charge. So they're going to ask specific questions, try to gain more information before they decide those next steps. One of the biggest misconceptions about an EEOC charge is that it automatically becomes a lawsuit. The EEOC here really wants peaceful reconciliation. They want you to work this through before it goes to courts. What they're looking for when they conduct their investigation is what they call reasonable cause. And that's reasonable cause that discrimination under one of those protected classes I mentioned before has occurred. So there are really three different outcomes that are going to happen as a result of the investigation once the EEOC has concluded. There is reasonable cause has been found, at which point you'll get a letter of determination. Option two is no determination at all. So there is no determination either way. They are neutral in whether or not discrimination has been found. The third option by the EEOC is they will tell you that reasonable cause has not been found. Discrimination has not been found as part of this particular charge or request for investigation. I'll walk through what each of those three outcomes mean in more detail. You might be surprised at the sheer number of charges that are issued every single year. Requests for an investigation by employees through the EEOC. In 2019, there were 72,675 charges. Now, we talked about the three different options. Let's walk through if reasonable cause is found. Once again, the goal of the EEOC is to find a peaceful settlement. So if reasonable cause is found, you will be working through a mediator, and they are going to ask the charging party to say about what they would like to be fixed, what needs to happen for everyone to be able to move forward. If a peaceful mediation and decision isn't found, that is when you can move forward, the charging party can move forward in private court. If the EEOC does not make a determination, the charging party, your employee or candidate, can request a right to sue letter, but only after 180 days from the charge being filed. Now, after that point, that individual doesn't have infinity to be able to file a lawsuit. They have 90 days from receiving that right to sue letter to make a determination to move forward against you as the employer. Scenario 3, if the EEOC does not find any reasonable cause that discrimination occurred in this situation, they will issue you as the employer and the charging party a letter, letting them know that reasonable cause has not been found. At which point, the same thing happens in scenario 2. The charging party can request their right to sue letter after 180 days, and that individual within 90 days from that point can file a suit against the business. It is not going on for infinity, and I think that's one of the concerns for employers, is it doesn't happen forever. Once that right to sue letter is issued, there's a 90-day window. So if they decide to sue 91 days, it's going to be dismissed, which is an important thing for you to know as an HR leader. The EEOC compliance and charge process is a complicated one, and it's easy to get tripped up, whether you're preparing for your HR certification exam with HRCI and SHRM, or you're in a situation where you have received notification that an investigation is happening. This is why I do like the flowchart option, because it is important to communicate to your leadership and executive team not to be freaked out. I certainly was freaked out the first time I received my first EEOC charge letter. It's important to work with your attorney and have a plan. This is why we have open door policies, and we also work to investigate every complaint or question or concern that comes into our offices within HR. My name is Jessica Miller-Merrell. I'm the founder of Workology. Workology offers resources to empower HR leaders for all facets of their HR career. One of those things is HR certification prep. If you want to learn more about these options, you can go to www.learn.workology.com and find out more about our HR certification prep offering for HRCI and SHRM certification.